Well, we've come to the last panel, and I'm sure you'll agree that Charles has done once again an outstanding job of bringing together experts in the area that we're exploring. I actually wrote down that here we are as we're at the closing panel, and we've seen expert speakers, and then I crossed it out and I put speakers that are experts. Not quite sure. I guess the answer is that what we've seen is certainly both this morning. So the topic that we're going to explore now is what beneficiaries should do when they suspect the executor, or executrix, I guess, of improper conduct, including conduct that amounts to fraud. Our first panelist, Craig Vander Zee, is a partner in Torque & Mains. He's certified, as many of our other panelists have been, as a specialist in estates and trust law. His practice includes all aspects of trust, of estate, trust, capacity, fiduciary power, of attorney disputes, litigation for clients. His clients have included individuals, trust companies, other organizations. He's a noted expert as a counsel on, amongst other things, the rights and obligation of estate trustees during litigation. And the list of expertise, as I ran through it, is enormous. Not only is he a litigator, but he's also served in the role of estate mediator, and justly his expertise has been recognized by his peers. He's been included in the Best Lawyers in Canada, chosen by Law Day as one of the 60 leading practitioners in Canada in the area of estates and trusts. And I note that in 2010 and 2011, he served as chair of the Ontario Bar Association Trust and Estates section. He's also a member of the advisory group of the Law Commission of Ontario project on the law as it affects older adults. And of course, with his expertise comes a long list of cases, once again, that he's been involved in. Our second panelist for our closing panel is Justin deVries. He's the principal of his firm, specializing in estate, trust, capacity litigation, as well as estate administration. He was at one point a partner both at Fraser Milner Casgrain, I believe it was, and a partner in counsel at Hull & Hull. So he's well known to our panelists and to many of our attendees here. He's the founder of a website all about estates.ca, which is a collaborative blog, quite popular on estate and trust matters. He's also a member of the of what's called STEP, Advocate Society Estate Planning, I believe, Council. Did I get that right? Of Toronto, and also the Council of Halton. He's consistently been named one of the best lawyers in Canada, Trust and Estates. I guess we have to be glad that Justin settled back in Toronto, because I'm looking at his resume and he did a little globe-trotting there in his early days, from an American law degree. At one point he did study at U of T for his BA. He's got a French language diploma from France, and he was also a Fox Scholar at Inns of Court in London, England. So we're very glad to welcome that he settled in Toronto to do his practice, where he's appeared also before all levels of the Ontario Court and the Federal Court, wide range of clients. He has both acted as litigator and mediator in contested wills, account passing, administration, trustee disputes, powers of attorney, and so forth. He's used his expertise as an instructor at the Ontario Bar Admission course, chaired a number of programs, and has been the contributing editor to the Ontario Civil Practice publication. He's acted as a court-appointed pretrial judge and is currently a pro bono disciplinary counsel for the Law Society. Many articles on the subject that we're looking we're looking at this morning. I think I like the OBA's Deadbeat. That's a good title.
I give.
Anyway, we welcome both as our closing panel to bring their expertise to this last subject for the morning.
Thank you very much for those introductions. I've known Justin now for 17, 18 years, and I certainly know him more intimately now after that introduction than I have otherwise. I'm going to chat about considerations when a beneficiary suspects that there is improper conduct on the part of the estate trustee. So I am not going to talk about fraud or the certainty of there having been a wrongdoing, although one is suspected. And what's the fallout, and what do you think about when that happens? First of all, it's thinking as to what is the issue and what's the context behind the issue. Because I may have a client that comes into the office and, to use Brendan's words, has moral indignation as to the conduct of a sibling, perhaps, or a family member who is an estate trustee of an estate, and they're a beneficiary. That is, my potential client's a beneficiary, and they're outraged with what's going on with the estate. And so that's the starting point. Well, my starting point is to take one step back and to say, okay, what are the basic questions that we need to know about, to know if there's even really a dispute, to know if there's really anything improper, and to know how the appropriate response, whether aggressive or non-aggressive in terms of litigation or no litigation, is appropriate and necessary. So we know that there's a duty to account on behalf of the estate trustee. We know that the estate trustee can't misuse funds. We know that the estate trustee can't pre-take compensation unless it's authorized in the will, or it's with the consent of all of the beneficiaries or court authorized. We know that the estate trustee shouldn't commingle assets with their own assets, and we know that they can't profit from the administration of the estate. They're entitled to compensation, to be reimbursed for disbursements and expenses, but they're not entitled to profit. Now, they may have other duties, but those are the ones that are commonly arise in circumstances with most of the clients. And so, what is the context? Knowing that that's likely one of the disputes. Is this an estate that's worth $250,000, or is it worth $25 million? What is the measured response going to be? Is this an issue over the fact that there is 1.5 missing or thought to be missing in investments? Or is it a situation where Johnny, as the estate trustee, gave away the china to someone in the family who wasn't supposed to get it? So what is the actual issue here, and what's the allegation of improper conduct? Is it the case that perhaps the estate trustee pre-took compensation, but they might be entitled to $50,000, and there's no issue with any of the other administration of the estate, but they've pre-taken $10,000? So what are we going to deal with in that context? When we think that a court will likely give them 50, they've taken 10, and they've done nothing else wrong. So it's understanding the context of the specific situation first before considering what the next step is going to be. Now, again, as I've mentioned, sometimes, and perhaps as many occasions as not, the alleged improper conduct is not done with dishonest intention or with malice. It's just done by way of, an honest intention to do the right thing, but not knowing what the right thing was and not having sought the correct professional advice. Sometimes it may be downright dishonest, and then obviously the appropriate response is necessary. So you also need to understand what is the current status of the administration of the estate. When a beneficiary is asking, what can we do? There's been something improper. Has the estate even been probated? Has any action taken place? Are you a week after death? Are you 2 years after death? Have the assets been disposed of? Have part of the assets been dealt with, but there's been no distributions? These are all questions that you want to ask as a beneficiary, or have a beneficiary ask themselves and to find the answers to. So dealing, first of all, in a situation where probate hasn't yet taken place, and there is a belief by the beneficiary, and there's evidence to support it, that the person who is appointed and is named under the will as the estate trustee will not properly administer the estate. So we're not talking here about a situation where there's a will challenge. Nobody believes that the will is invalid. They just don't want the person who's the named estate trustee to be so appointed. So what do? Well, you can file a notice of objection to the appointment of that individual prior to probate. You would also, in certain circumstances, then bring an application to the court to deal with the appointment of the estate trustee. Now, simply because there is a dislike as between the beneficiary and the estate trustee is not going to be sufficient to not have them appointed. And in considering why they might not be or ought to be appointed, one would look to things like, is there inherent conflict of interest? Are they already telling people that they're not going to abide by a proper administration of the estate? And by that, they're not going to honor certain bequests because they think they know better and what the intention of the deceased was. Well, in that particular case, there's no faith that they are actually going to administer the estate properly. And if there's evidence of that, then that may be enough to have them not appointed. What if they actually have a conflict of interest economically? What if they have a claim against the estate? Someone can't sue an estate and defend it all at the same time. So maybe that would be a basis up front as to why someone ought not to be appointed as an estate trustee when indeed they're named as an estate trustee under a valid will. So then it's looking at, well, if not them, who? So then the mind has to change to, in terms of going to court, if you're saying that one individual ought not to be, well, then who should be? And so should it be, as is often the case, should it be a trust company like Scotiabank coming on board as an estate trustee during litigation, or as the estate trustee if litigation is on the horizon or is there? Or should it be someone else who is trusted and everybody accepts as the rightful person to administer the estate? So that's dealing with the appointment. Then, depending on the complexity and the seriousness of the alleged impropriety, one might look to, well, do we need to go to court at all? Is this something that can be settled out of court? Can it be something that's dealt with by way of letters, calls, family meetings, to try and try to nip the situation in the bud so that it doesn't cause everyone in the family or the estate to incur needless tens of thousands of dollars by going to court, when all it might take is getting everybody in a room, perhaps maybe everyone will indeed be represented by counsel, but getting everybody in the room before it escalates to a level that is either going to be very costly or that causes disharmony in the family. In that vein, there can be agreements that are reached by all the beneficiaries as to how the estate's going to be administered. Still honoring the will, but the manner in which it's going to be administered. And by that I mean, some people might be concerned as to the timing of the bequests. The estate trustee might be saying, well, I think it's going to take me 3 years to administer this estate, and while there'll be enough money for the bequest, I don't know that that's going to be the case, and you're going to just have to wait 3 years. Well, maybe that's just because the estate trustee doesn't really know all the steps to take and isn't taking them in an efficient manner. So it could be that everyone who's a beneficiary, they may have an issue, but they might be able to reach an agreement prior to going to court as to the nature of the administration. Sometimes it's just about informing the beneficiaries on the part of the estate trustee, or being informed on the part of the beneficiary, that can avoid a dispute. Many times clients will come in and will say, they're not answering my questions regarding what's in the estate, what it owes, and when I'm going to get paid. Well, usually it's the last question that's first, but typically you're dealing with all of those questions. So perhaps all it is contacting the estate trustee and having them providing a list of assets, bank documents, copies of tax returns, a copy of the will, copies of appraisals of property, if they haven't already done so that the beneficiary is fully informed. And then when looking at those documents, the beneficiary says, oh, I thought there was improper conduct, but there actually isn't. It's just taking longer, and I didn't understand that that they had to apply for a tax clearance certificate up to date of death, given the nature of the estate, and that it was imprudent to distribute before then. Well, once they find that out, then maybe they're fine with it. But what about the case when they're not fine with that? Well, then we're off to court if it can't be resolved out of court. And so there are a number of different types of remedies that can be pursued in court. Could very well be, and the most typical one is an order to require the estate trustee to provide an accounting and pass their accounts. It could be that before going to the stage of doing an actual application to pass accounts, that accounts are to be provided to the beneficiaries to review, that is, their professional advisors review with them, to determine if there's anything wrong. They might then say step 2 is go to court. But if step 1 is answered by the provision of proper accounts that properly account for the administration, then litigation may be avoided. But there are many circumstances when it doesn't, and so you're off to court with an application to pass accounts in order to deal with that. Sometimes when you're ordering that accounts be provided, you might be seeking ancillary relief at the same time. You might be seeking that certain assets be protected, that certain assets not be distributed, that certain steps be taken by the estate trustee that haven't been taken. Perhaps they haven't filed tax returns like they're supposed to. Perhaps the administration has gone to the point where they're supposed to be transferring assets from the estate into testamentary trust. They haven't done that. So maybe they're not intentionally mismanaging the estate, so there's no malice here, but they're just not acting in the way that they need to. And maybe the right answer isn't removing them. Maybe the right answer may simply be requiring that they fulfill certain steps by certain times, including an accounting. There could also be injunctions, and here is one of the key issues which is always at the forefront of any of these matters is, are the assets safe? And are the assets where they're supposed to be? And if the answer to those questions are no, then there has to be serious discussions about what kind of action, whether it's immediate or otherwise, has to be taken to safeguard the assets. So by way of an example, what if an estate trustee has transferred a property to himself or herself and they're not entitled to that property under the will or otherwise, but they've done it. So they're clearly acting in property. Well, there might be an immediate application, one seeking their removal, two seeking an accounting from them, and an application to require them to pass their accounts, freezing that assets, even if it's their personal assets, putting a certificate of pending litigation on that property so it can't be sold by the estate trustee until it's fully adjudicated. So it's about safeguarding the assets and understanding what assets have to be safeguarded and what's the best manner of doing so. So aside from freezing the assets, another alternative might be ensuring that no distributions are made to any of the beneficiaries until all the steps in respect to the administration has taken place. There can also be claims that are made against the estate trustee, either by way of dealing with an application to pass accounts and reducing their compensation or eliminating it in the case of a negligence situation if that's proven, and also perhaps not allowing them to be reimbursed for expenses or disbursements that they say they're entitled to under the estate. There are many more avenues that you can pursue. Charles has told me that I have a minute, so I can't really do justice to the whole topic. But I would refer you to the two decisions, the two cases that are in my paper as well. One is Zimmerman and Fenwick, which is also known as the McMichael estate. That's an interesting read, given that many may know the McMichael name, but also how there was improper conduct in that case and how it was dealt with by the court, and also the Langston and Landon case, which is commonly referred to as the Penna estate. In that particular case, there were three trustees, two of which were thought to be acting properly. One was the problematic estate trustee. They, in turn, brought relief against the problematic estate trustee, and problematic is generous, to say the least. In that particular case, it was dealing with the thought that $24 million was missing, or had been wrongly spent from the estate. So the relief in that court that was sought just quickly was the estate trustees hired a forensic accountant. There was an injunction to freeze whatever and protect whatever assets in the estate could be protected. A certificate of pending litigation was put on one of the properties that was misappropriated by the estate trustee, even though it was considered a personal asset, and his other personal assets were frozen. The Bank of Nova Scotia Trust Company was appointed as the estate trustee during litigation, and there was actually formal claims that were brought in a partial summary judgment that were pursued as part of that case. So it can get extremely complicated, and as you can see, it can also get very costly. And so in dealing with a beneficiary who, first of all, alleges from the get-go that there's improper conduct, you want to start and understand what the story actually is, and that it's not just a situation of brother against brother who don't like the fact, who may have been estranged, and also one brother not liking the fact that dad or mom preferred them to be the only beneficiary over the other. And that's what's really stirring the pot here. It has nothing to do with improper conduct. So with that, I'll turn it over to Justin.
Thanks, Craig. Thanks, Charles. I'm a newbie here. I've never appeared on this panel, so I'm glad to be here. Unfortunately, I come at the end. Some people call that the anchor. Other people would call it the dreaded position to be in. The room is thinning out. People are looking at their BlackBerries and heads are nodding. But I've brought slides, a bit like ice cream, I hope, to a birthday party. The other thing I'm going to do, because I don't have a remote, is I'm going to stand up. I'm going to take that mic and I'm going to stand over by my PowerPoint. So my apologies to my cameraman, who won't be very happy with that. But hopefully you'll look at the slides and not me. So I'm going to pull a bit of an Oprah and walk around the room. So I'm talking about two distinct things, a handwriting expert and then trustee indemnification for expenses. They're two separate topics. So a handwriting expert, I just found two quotes just to show you that when it comes to handwriting, it's a bit of a mug's game to some extent. The second quote is probably a little bit more interesting. It's hard really to tell much about someone's handwriting, but nevertheless, the courts do look at handwriting experts when it comes to fraud and to estate. So we know that fraud is not restricted to the living. We've seen that. So the question often becomes, I think there's a fraudulent signature. My apologies to those in the back. My fraudulent signature on a will. Can I retain a handwriting expert? So there's two branches when it comes to the so-called science of handwriting. One has been thoroughly put aside, I suppose, and that's trying to tell from a handwriting what your characteristics are, if you have too many loops or if you're straight. So we don't look at that in our world, but we do at times look at forensic handwriting, where there's a comparison of handwriting or signatures to determine if a signature on a will, for example, or a trust is fraudulent. So again, as I said, often handwriting experts are called to give evidence, but the court is cautious when it comes to that. They'll often hear what the evidence is, but they may not put a lot of weight on the evidence. And of course, that's how lawyers deal with a lot of evidence, especially in a more modern setting than traditionally. We always look at weight. So we may let it in, or the court may let in evidence, but the question becomes how much weight to put on that evidence. So is it persuasive to the trier of fact, which is the judge? So it's easy to understand both the methodology and the results, and the weaknesses can be easily spotted. So this is why judges put often little weight on it, because they think they're handwriting experts to some extent. We can all look at someone's signature and say, well, that looks a bit different, and I understand they were a bit feeble when they signed it, so that may explain why it's a bit different. So judges often are not going to rely entirely on a handwriting expert when it comes to looking at a signature. So there's strategies. What do you do when you're faced with a handwriting expert? And this is really when you're at trial. And there's two ways. You can argue that the opinion is inadmissible on its face, or you can attack the reliability of the expert's opinion. So there's rules of evidence, which I won't bore you with, but if you look at the following factors that are highlighted there. This is some of the ways that you can really try to exclude the evidence so it's not even heard. So it doesn't even get before a judge. It's not relevant. It's not necessary, and there may be a reason that it should be excluded or not included. So we have some rules that even though on its face something should be excluded, we nevertheless allow it in. A deathbed statement is a good example of that. Someone says, I shot and buried, Jimmy Hoffa, and he happens to be in this parking lot. That may have some weight. So attacking the expert, this is what people often do. You can say an expert is not properly qualified. And in this field, it's relatively easy, only because there's no degree you can get, really, in forensic handwriting expertise. There's no university department you can call up, for example, and get Professor Dumbledore or someone like that to speak to these matters. So qualifications are often dubious. And there is case law where handwriting experts have been attacked on that basis. If you do find an expert, it's usually someone who is a retired police officer, someone with the forensic department at the RCMP, but even that doesn't necessarily mean that they have any qualifications that we would recognize in a court of law or even in a lay setting in terms of having degrees. They may have experience, though. What you can do as well is rather than attack qualifications, unless it's very obvious, and that's how you exclude it from the very beginning, you say the person is not an expert, the court should not pay attention to their opinion. You can cross-examine the expert, so allow the evidence to go in, but then whittle away at it by having a strong cross-examination, and that goes to weight. The court will say, we're not going to put a lot of weight on that. Here's a case in 2004 where two last wills were challenged, 1980 and 1994, and the forgery was alleged for both wills. So, it's a remarkable period of time, so the rogue must have been very active. So an expert claimed that a will that was done in 1977 was used to trace the signatures on the two other wills in 1980 and 1994. Here the drafting solicitor came along. Now this is 1980. He said he had a dim memory of the person signing the will and that it was practice to have them in the room when they were signed. But here the court preferred the evidence of the handwriting expert over the drafting solicitor. So this is a case where the evidence did go in, but it's largely because here the solicitor really didn't have strong evidence one way or the other. So the court would look to some means in which to evaluate the signatures. Here the judge didn't go on his or her own lark and make a decision about the evidence by looking at it. In this case, this is a bit earlier, 1973. So again, there are not a lot of cases around. So going back 40 years now, not quite as long as Queen Elizabeth, but nevertheless, we're going further back. The signature on the will alleged to be forged, and here you had two handwriting experts battling it out. And the court decided it was going to do its own comparison, as judges are wont to do on occasion. They took the analysis prepared by one of the handwriting experts, and the judge came to his own conclusion in that case. A 1999 case, this is a little bit more interesting, I think, only because no one saw really anybody or the testator write the will. There wasn't a lot of evidence about the surrounding circumstances of the drafting of the will, and not surprisingly in our world, that is the estate world, the family was evenly split. So some people said, oh no, that's the signature, and other people said in the family, no, it's not. So here, the court actually said that we need an expert opinion in order to come a little bit further out of the hopper and decide whether or not the signature was forged. So takeaways, you have to ask yourself, do you need a handwriting expert? What kind of qualifications am I going to get from a handwriting expert before I ask them for an opinion? I think you have to clearly define the mandate to try to keep it as narrow as possible so they don't open themselves to attack by going too far. What documents are available? Handwriting experts always like to look at many original documents. So is that there? And also the availability of any corroborating evidence. So is there other factors that we can use to attack or support the signature? How am I doing on time, Charles?
You still got time.
Still got time. Okay, trustee indemnification. This is a separate topic. It picks up more on what Craig was saying. This is what some people might call soft fraud or partial fraud or maybe fraud. But as Brendan said, we don't really like using the word fraud as litigators. It has a big consequence on a variety of levels. So we tend to shy away from that unless we have very strong evidence. But as most of you know, a trustee, be it for an estate or a trust, is administering the will, and they, of course, incur expenses, and the question becomes, well, what happens with those expenses? Common sense would tell you that a trustee can look to an estate or a trust to pay for proper expenses, but it's never that easy because, of course, what is a proper expense? Often the trust instrument, that can be a will or an actual trust, will be silent on indemnification. There will be no directions given by the testator or the settlor of the trust. And trustee indemnification is both a rule of equity, so that's a rule of fairness in the secular courts, and also guaranteed by certain statutes that look at estates and trusts. So Section 23.1 of the Trustee Act is one of those statutory provisions which says you have a right to be indemnified for proper expenses. Beneficiaries, of course, can object to improper expenses, and the trustee can be ordered to repay anything that was denied for reimbursement. So what is a proper expense? So it's supposed to be incurred for the benefit of the beneficiaries or preserving or increasing the value of the trust property. So again, common sense. Someone is doing the right things to help preserve the trust or increase its value, or for the benefit of the beneficiaries. I'm getting an expert opinion on transferring a difficult piece of real estate, and I need to go to a real estate lawyer in order to do that. Accounting expenses when it comes to taxes, those kind of things are for the benefit of the beneficiary, or beneficiaries, and not of the trustee. Unfortunately, the beneficiary always has the benefit of hindsight. So what you think is a proper expense, a beneficiary, of course, is going to say it wasn't proper, it didn't quite work out the way you wanted, you should have never spent the money. So again, this is where lawyers, to some extent, have a field day because, of course, we argue back and forth about whether something was a proper expense, and often it depends on the facts and the circumstances. So things to consider: whether an expense is proper, the nature and extent of the trust. So, what does the trust document say? What's it about? What are the terms? How much is it worth, of course, because if it's valuable or that much more money in the estate or trust, you can justify bigger expenses. Is it necessary in order to preserve the trust? Are you acting within the scope of power? So that's the trust deed or by statute. Whether it was incurred in good faith, you're trying your best in the circumstances, and whether it arose during the course of, or when, rather, it arose during the course of the administration. Some of these expenses are more common in the beginning as issues come to the fore and a trustee is struggling with coming to an understanding. So how about hiring an agent? This is a fairly common expense that people engage in. So in this case here, the Stephen Thompson Family Trust, the court held that the decision to hire an agent to administer a trust was clearly misguided. So sometimes people hire agents to help with the administration of a trust. That's for another day. There's lots of issues with that. But in any event, you are entitled to hire an agent to get some guidance and with some assistance. The court held, though, here that the costs of hiring the agent was to be borne personally. What they did, and it was not very sensical, is they hired their former trustee as the agent, even though that former trustee was clearly in a conflict. So that didn't quite make sense. So he was removed, the agent, because there was a conflict, but then, or he was removed rather as the trustee initially, and then they hired him as an agent. So the court, not surprisingly, said that was offside. More interesting, perhaps, is the defenses they tried to raise, that is the trustees, who replaced him and then hired him to administer the trust, is that they were allowed to hire an agent. Often a trustee or an estate will say you can hire an agent. That's perfectly fine. And they were also released from liability, or there was an exculpatory clause, which also has generated lots of heat in the law over a number of years. This is what Justice McCarthy had to say Again, bottom line is that an exculpatory clause, that is, no liability clause, doesn't give you writ large to go out and do whatever you want. You're still going to be held accountable. The court still has a role to look for proper expenses and to make sure that things are going well. I have 1 minute left. Let's see what else is. It's Craig's fault. He took too much time. Legal fees is another thing that we often have fights about when it comes to a trustee. Now, so a trustee can hire counsel in order to assist them with the administration of the estate or with litigation or some other aspect. Of course, they can hire counsel who becomes counsel to the estate in order to help with the administration, as I said. And usually there's a right to full indemnity for those charges. So legal fees are a first charge on the estate, and they're to be paid out of the estate. Why? It's a benefit for the estate or trust. That's the bottom line. There's a direct benefit there. So again, we always go back to the will. You know, if you're involved in these situations, read the will carefully, take the time, read a trust deed. And you're entitled to look, for example, to pay an agent when it comes to legal fees when you're talking about the interpretation of a trust agreement or a trust deed. So often they're difficult to understand, or there are provisions that are contradictory, so you can look to the trust instrument itself. Or if there's third-party claims that are brought in, so there's litigation that's ongoing, including a dependent support claim, for example, as an estate trustee, you have to defend that. Let me just give you one case, and then I will sit down. This was an interesting case. The captain case, two Dutchmen were having a go at one another. I can say that because I'm a Dutchman. And so they spent a lot of time litigating against one another. And the usual rule, as I said, is that a trustee's right to be indemnified for proper expenses is a first charge against the estate property. But here, Justice Brown decided that wasn't the case. It's not always a fixed rule, so a lot depends on the circumstances. So the court acknowledged that, yes, there was legal fees that were generated because we had an interpretation application of the will. So it wasn't altogether clear what the will was saying. There were codicils. There were some other issues that were surrounding the estate. So here the court recognized that, yes, counsel was involved and the estate trustees had a right to retain lawyers. But the court also said these two gentlemen went too far and that the application was unreasonable. They basically could not get along, and there was a lot of money, so it was an excuse to keep fighting. So the court ultimately only allowed legal fees of $350,000, which seems quite a bit, but in the context of the case, it was not. And that was per side. But the court imposed a condition, which is rather than making the trustees' legal fees a first charge, it became the last charge on the estate, with the obvious possibility that there may be nothing left once you distributed everything else. So that's, again, a good example of where, yes, there was a proper expense, but the court still sanctioned certain behavior. So conclusion from all of this is if you are involved with an estate or a trust, either as a beneficiary or you are administering the estate, you have to think long and hard about what you're doing. It's not carte blanche to just run amok if you're a trustee. As a beneficiary, you should also think long and hard about challenging an expense unless it is improper. Communicate on both ends to see if you can get around things. If there is disagreement, you can always go to court, is a way of doing that, to get directions so that you can see if it was of benefit to the estate. And a trustee should always communicate, as I said, with the beneficiary. Tell the beneficiary or the beneficiaries under a trust exactly what you're going to do, why you're spending the money, and hopefully you'll avoid the problem. Thank you.
Are there any questions? Okay, I have two, actually. I'm just going to do the first one to Mr. Vander Zee, since he's sitting. One of the things that I find difficult when I handle these types of cases is that while there's an absolute duty to account, both statutorily and by common law for both an estate trustee and a power of attorney for property, that rule is honored in the breach. So I put the following hypothesis to you. Let us assume that the estate trustee or the power of attorney has not kept any records, not because they want to defraud anybody, because they just don't keep records. Paid all the money in cash. What risk is there to them if they can't locate the vouchers to prove that they were proper expenses?
Okay, there's a couple of issues that arise from that. One is nothing may have been done incorrectly. Everybody might agree that they got what they should have got. So the mere fact that someone doesn't have accounts doesn't mean that they're susceptible or liable to a damage claim. There would have to be damages that arise out of that. However, if there's residual beneficiaries, they're going to turn around and say, we don't know that we're getting the proper amount of the residual estate because you haven't accounted. So one of the first basic tenets regarding an administration of the estate is that the estate trustee is personally on the hook for what goes on. So if the estate trustee cannot prove their accounts and there is a shortfall of funds, or there is a claim for mismanagement and they can't disprove it through their own accounts, then they're going to be personally on the hook. And at the end of the day, maybe they'll be on the hook for the legal costs that go along with the whole process to get through that and to get to a conclusion, whether in court or by way of a settlement, that there's not going to be any pursuit of a claim against the estate trustee for failing to have the accounts because everybody is ultimately satisfied or not willing to pursue it further. But the estate trustee has brought it on themselves. Now, typically, there would be some sort of records of some sort. There would be bank account statements likely from date of death, or there would be tax returns that were filed, or there would be some sort of evidence as to what went on in the estate. But one of the very first things that I tell a estate trustee when I'm meeting about an estate administration is, you keep everything. You keep a file folder of receipts and you keep a file folder of disbursements, and that means you keep every bill, invoice, or record. Because when you do an application to pass accounts, the beneficiary is entitled to say, I see here you have a receipt from 3 years ago. Can you provide that to me? And you better be able to have it, or you're going to have to come up with an explanation if you don't, if it's not a typical expense in the ordinary course. For example, could be utility expense for a property owned by the deceased that has not yet been sold or distributed. And for 2.5 straight years, you can see that utility expenses have been paid and you don't have it for 1 month and then it starts again. Well, that is going to be relatively easy to show, and there would be some record from the utility company. But if there is nothing there, then the estate trustee is definitely put themselves in peril, and they've put themselves, or at least left themselves, open to a claim.
Justin, I have one question to you, especially regarding the lawyer's issue. The executors or the power of attorney are all fiduciaries. That means they really can't delegate. So when they appoint an agent, do they risk, like a lawyer, to do stuff that they might otherwise be able to do themselves? Do they risk reducing their compensation at the end of the day?
Absolutely. So a trustee cannot delegate their decision-making authority. So you can delegate someone to help you administer an estate. But for example, if you're selling a house, you can hire a real estate agent to help you list and sell the house, but ultimately the sale price is something that you have to accept or reject as a trustee, for example, or as an executor. You can go to a trust company, for example, or a bank, and they can provide assistance to you, but you will see when you're dealing with them that they will only go so far. And then, of course, if you pay an agent to do your work, remember, compensation is not a freebie. Compensation is supposed to reward you or compensate you for your sweat equity in administering an estate. It's not an automatic. It's a suggested scale of compensation that the court can look at. So if other people are doing the work and you're paying them, that's your compensation. It's not a bad idea, though. It's not fun being an executor sometimes. Your fiduciaries, as you've just heard from Craig about the requirement to keep accounts. There's other requirements. You're held to a higher standard. The court will have little sympathy with excuses. You're not allowed to be a passive estate trustee. If you don't want to do it, don't accept the mandate.
Okay, thank you.
Can I just ask one question of Craig, actually?
Sure.
Sorry, just a question for Craig. This is not turned on. I'll try to speak loudly. You spoke about the duties, obviously, of an estate trustee to keep accounts. In light of the deVries decision, where an attorney for property, who was then additionally the estate trustee, was required to account to a residuary beneficiary, to what extent would it be prudent to advise attorneys for property to keep records?
The very first thing I would tell them the duty doesn't, in my view, the duty doesn't change. You're still a fiduciary. So and it's something that I do if somebody gets appointed as a guardian of property. In my letter to them and in my discussions with them, I am talking about keeping all records. That's all receipts and all disbursements. And just keeping file folders for each and every one. And every time there's a receipt, you put it in a file folder or however you wanted to keep your records. But that doesn't change with the power of attorney situation. And especially the case because attorneys for property will be held to account to the public guardian and trustee as long as the individual is living. And perhaps others, but certainly the public guardian and trustee. And so they need to account in the same fashion that an estate trustee would, in my view.
And so even where the grantor consents and says no need to do so, I'm well aware of what you're doing.
But it's not the grantor who's ultimately getting reported to in an
Correct.
attorneyship. It's the PG&T. And what happens if they say, and it could be a situation, and again, many of them are this way, everything is very friendly. Everything is happening the way it should be, and it's now 6 years down the road, and there's been a turn in the health of the grantor of the power of attorney. And then all of a sudden there's an issue with one of the assets, and a family member steps forward and says something. Well, then there's going to be a situation where that person may call the PGT. The PGT gets involved. The PGT doesn't know anything about the grantor except that the grantor is in no position to comment on anything anymore because they're no longer, they're not even in a position to say what even happened in any of the circumstance. And if they don't have capacity with respect to their property, then the PGT is not going to go to the grantor and say, well, you didn't understand how to manage your property, so we're going to take it on board that you said that other people didn't have to keep records as to managing your property. So I think that in both cases, before death and after death, that the fiduciary should maintain the records at all times and completely.
Thank you.
If I could just add quickly to that. I suggest you take a look at the Substitute Decisions Act and who may be entitled to bring an application to compel a passing of accounts. I think it's Section 42. And it includes...
Sorry.
Yes, that's okay.
Yeah, I think that's right.
And it includes not only the OCL, the PGT, but it also includes debtors. And it includes any other person with leave. And then I also suggest you take a look at the regulations, which talks about the statutory obligation, not a suggestion, not an invitation, but a statutory obligation of how to keep those accounts.
Thank you.
Thank you. I'm going to introduce Frank Diamond, and I'm going to make it very short. Frank Diamond is the CEO of B'nai B'rith. He is a courageous, determined, resolute advocate for the Jewish people and for human rights across Canada at large. He is unafraid. He's unintimidated. He can't be bullied except perhaps by his wife, Flo. His public persona is very well known, but what is unknown about Frank is how many people, as we say in Latin, stille heit, come to him for help, and how he doesn't really turn anybody away. and I consider him a very good friend and a role model. And before you give us a closing remarks, I'd like you to pick out the two winners for today, for the lottery.
One.
First winner is Linda Summers, and the second winner is Dominic Campione. So, David, is Mr. Lichtenstein here? So if you can come and take these cards. These winners are going to be getting a shirt, either a court shirt or a regular shirt from, what's the name of their company? Made to Measure. Okay, thank you. Go ahead, Frank.
It says 5 minutes, but it'll be 60 seconds. I want to commend all of you for sitting here since 7:30 a.m. You really have resolved to listen to everything that's been said. My obligation here is to make a quick pitch, which I will not do. I will not ask you to think about B'nai B'rith when you're writing wills for your clients. We're going to send you material on our Alzheimer home, on our advocacy, on our affordable housing, and our seniors programs. So I won't take your precious time right now. I want to thank Charles, because without him, none of this would happen. He's committed to the program. He's been a chair for B'nai B'rith in this area for several years, and on behalf of the organization nationally, I want to thank you for your dedication, commitment to seeing through this great program. Thank you, Charles. I want to thank Anita Bromberg, who flew back from Israel last night, where she attended the Global Forum on Anti-Semitism for us. She wanted to be back here this morning, and this is the way she's celebrating her birthday. So happy birthday, Anita. Thanks to Catherine Tang and Carmine Young, who were administrators in this endeavor. Thank you so much for all that you have done for us. None of this would be possible without the Scotia Private Client Group, especially John Clegg. So thank you so much for your participation and support. It makes the difference. It makes a fundamental difference. To Wagner Sedlowski, to Wheelie Estate Litigation, Hull and Hull Barrister and Solicitors, and I'm going to put in a plug for the Jewish Tribune, which is the largest Anglo-Jewish publication with a weekly circulation of 62,000. Should you wish to advertise, we'd be happy to have you participate in that program. And I wanted to recognize a good professor, but I think he's already left the room. So once again, on behalf of B'nai B'rith Canada, thank you. If you can help us in any way via your clients, we greatly appreciate it. Have a good day.